Last time we heard crime lab analyst of the field team, John Ertl, explain how their team was kind of sidelined during critical searches. The defense then pushed on discrepancies in the photos, questioned whether fingerprints or DNA should have been found on the RAV4, and then pointed out the lack of blood spatter in Stephen Avery's home or garage. And by the end, it felt less like a really clear picture and more like this puzzle that had a bunch of missing pieces. Welcome back to the Avery trial. This is episode 24, and today we pick up right where we left off. John Ertl is still on the stand. If the last episode, episode 23, left you with some questions, you are not alone. In this episode, we hope to find some answers to those questions. As I've always told you, I do not read ahead on these things, so I don't know what's going to happen any more than you do. So let's go ahead and get started with the continuation of John Ertl's testimony. And we have the defense attorney Buting pick up right where he left off. So everyone's back from lunch, and his questioning continues. He says, "All right, Mr. Ertl, I'm not exactly sure where we left off, but let's talk about luminol for a minute." All right. Luminol is this substance that reacts to a number of different things besides just blood, right? That's correct. Other kinds of chemicals, you mentioned cleaning agent. Bleach reacts real highly to that. Very strong? Yes. Which means very bright? Bright and fast. Yes. Okay. What about other kinds of things? Transmission fluid, perhaps, oils, things of that nature. I know it reacts with some metals, copper and lead in particular. Transmission fluid might have some metals ground into it, so it's possible. Okay, maybe it would not be as strong a reaction, maybe a faint reaction, something like that. Perhaps. Okay, I'm not sure. And this is a garage. Let's go to the garage floor for a minute, where you said you had a faint reaction in this little area, 3x4 area, right? Not a real bright, quick reaction like you get with bleach, for instance, right? And the area then, you then sampled and tested with phenolphthalein after that, right? That's correct. You turned the lights, and then you used these very sensitive phenolphthalein tests to see if there's any possible blood? Correct. And that would be human or animal, right? That's correct. And that particular area, you didn't find any kind of blood reaction at all? That's correct. But there were some other samples of blood that had been recovered earlier, as far as you could tell. That's what I was told. And do you know, did you ever find out what the results of those blood, whose blood it was or wasn't? No. That comes later, not part of your responsibilities. Is that right? That's correct. Okay, all right. Let me switch and talk with you for a few minutes about the burn pit, okay? You talked about some experience that you had being called out to the woods to look at bones or something of that nature. There had been a couple of burial sites, and one in particular earlier that year that it involved burning. Okay, and so you have enough experience to be able to recognize bones? Yes. Not necessarily distinguish human bone from animal bone, but you can tell what's bone and what's rock and that sort of thing. Yeah, I could. Maybe not all kinds of rock, but bone from, say, plant materials, piece of bark. Bone from, you mean you can distinguish bone from plant materials or bark? As you pointed out, I have a background in plant biology, so I feel comfortable with plant materials versus bone, but not so comfortable distinguishing, say, some limestone versus a piece of bone. Okay, and you are not actually a forensic anthropologist. No, I'm not. Did, to your knowledge, did Mr. Fassbender call a forensic anthropologist out to the scene of the burn pit? Not to my knowledge. Or Mr. Wiegert? No, not to my knowledge. Okay. Now, you talked about excavating this site a little bit. Do you know how a possible bone site is supposed to be searched by, what an archaeologist or forensic archaeologist or anthropologist would do? Attorney Fallon, of course, of the prosecution, says, objection, compound question, which is it? Attorney Buting then says, archaeologist. And the answer is, I have no training in archaeology. We do excavate burial sites differently than we excavated this ash pile. Okay. And when you do that, one of the very first things you do is make sure that you document it with photographs before the site has been altered, right? That would be the first step. And that, in fact, you take numerous photographs throughout the process, documenting it before, during, and after, right? Quite often, yes. And that the proper way is to sort of establish a contamination path, let's call it, an area outside of the area that you think might be worthy of excavation, where you are allowed to walk back and forth and not worry about contaminating anything. Is that right? Well, that's generally true with most crime items. All right. You want to limit the access to the site in some way. Okay. But when it comes to excavating one of these sites where there might be a burial site, for instance, yes, you divide it up into either with string or something. You ideally would have 4 posts outlining the area with strings and then dividing it up into various squares or quadrants. Are you familiar with that? I'm familiar with that. In my little knowledge of archaeology, I have seen that done. I have worked with forensic anthropologists at burial sites, and they have not done that. All right. But one of the things when you do that is you work from the outside in. In other words, from where the outer edge is, where your path is, you work your way, the outer edges first, and then you work your way into the center first so that you can do the entire area. Well, usually with a burial site, your first goal is to define the extent of the hole. So once you have defined the perimeter, then you work outside of that and dig down alongside of where you think the burial site actually is. And then you excavate from down and sides and underneath to the core, okay, to where the body would be. Sort of outside into the middle, right? Correct. Generally, when you do discover an item in the course of that excavation, it's important that you make note of exactly where in that within that perimeter area you find that bone or that item, right? In my past experience, we would, if the body is intact, we would locate where the head is, where the shoulders, the joint, and the hands would be, where the hips are, the knees, and the feet, just to get the orientation of the body in the grave. Okay. Now, at this site, you didn't have a perimeter with a containment path around it, right? I mean, it was being worked on by the time you got there, right? Well, it wasn't a burial per se, so it wasn't a great perimeter. There was a scooped out area of dirt with ashes, right? So the ashes was our perimeter. Okay. But somebody would use the shovel, you said mostly you, but sometimes others, and dig up a portion and bring it over to be sifted, right? Right. And this area, the whole area that was excavated, was about how big? Probably roughly the size of this table I'm sitting at. And nobody, when you would bring over a shovel here or shovel there, nobody made or kept track of where exactly in that, I guess we should identify it for the record. The area is what? Maybe 5 by 4? 5 by 4 feet. Yeah. Okay. Nobody made or kept track of where within that area any particular suspected bone may have been, right? No. And if any suspected bone was found outside of that area, nobody made specific note of just where outside of that area that came from either, did they? Attorney Fallon then says, objection calls for hearsay knowledge. And it's non-specific as well in terms of who, what, and where. The court says, well, as far as hearsay, I understand you to be questioning this witness. I'm assuming he's asking the witness based on his own knowledge. What was the remainder of your objection? Attorney Fallon says it's non-specific in terms of what was found where, when, by whom. If he's asking the witness what he may have done and what he may have documented, that's certainly appropriate. But what anyone else may have found, done, or documented is, the court says, I will ask you to rephrase the question for clarification. Attorney Buting then continues. All right, I guess the point here is that various items of suspected bone were brought to you to be sifted. I mean, various areas of dirt or whatever were brought to you to be sifted, and then suspected bone fragments were found, right? Correct. But to your knowledge, neither you nor anyone else would specifically identify where in this area that particular piece of bone came from? No, everything that was collected in this area was placed together in a box. This area being that 4 by 5 foot ash pile was placed together in a box, just as we had done with the burn barrels. And did you find anything? Did you sift anything outside of that pit area on the grass or farther over above where the dog was in that picture on the mound or anything like that? No, we were restricted to the ash pile. Okay. And you just worked on it that one evening? Yes. You didn't come back the next day to do any further work? No, that was the last day I was there. And that was done actually at night, you said? Well, we worked up until it got dark. Was it daylight when you got there? It was approximately from 3 p.m. to 5 p.m. Okay. So it was daylight for part of it, and then you kept working until it got too dark? Got too dark. And you went walking around during your, how many days was it there? 3 days? 4 days? Saturday, and came back for Sunday, Monday, Tuesday. Okay. So during your 4 days there, you walked around different areas and looked at different buildings on the 40-acre property, right? Yes. Testified to that? Did Mr. Fassbender or Mr. Wiegert ever escort you to a aluminum smelter on the property? No. You never saw the smelter on the property at all, did you? No, I didn't. And you are the one who has the experience finding bones, right? I have some, yes. So if somebody had brought you over to the smelter, you would have been able to look carefully with your experience to see whether there was any evidence, fragments of bones or whatever, in or around that smelter area, couldn't you? I don't know much about aluminum smelters. If there were something to look at, I could have looked at it. Okay, but you did not, because no one escorted you there. No one showed you the smelter. I didn't know anything about an aluminum smelter. What about a big wood furnace? No, I don't know anything about that. Never looked inside of a wood furnace that was on the property to see if there was evidence of bone or... No, I did not. Zippers, poles, anything like that? No. Attorney Buting then says, all right, thank you very much, sir. The court says, any redirect? And Attorney Fallon says, yes, Judge, thank you. And the redirect is begun by Attorney Fallon. A couple of points, Mr. Ertl. First of all, I would like to ask you about this question relative to the transportation of the SUV. Counsel asked you if you could have remained and helped with other searches instead of going with the vehicle to Madison. What is the protocol? What is the recommended procedure for the crime lab analyst when there are two of you there with a critical piece of evidence like the SUV? Well, I was asked if we could get the vehicle back to the laboratory and asked to see if I could expedite getting work done on it prior to Monday morning. Who asked you to do that? It was either Investigator Wiegert or Special Agent Fassbender. All right. Now, in terms of transportation of a key piece of evidence like that, is there a concern on the part of the analyst that the evidence would be transported safely? Well, definitely. I wanted it enclosed It is now in my custody. We could have turned it over to Calumet County, and they could have taken custody and dealt with getting to it to the laboratory. But you took control of the SUV, correct? Correct. All right. And to ensure that it was safely transported to the crime lab without incident, took 2 of you to do it? Correct. All right. Now, a counsel asked you a couple of hypotheticals about the presence of a certain Toyota key and the possibility of DNA on that key. Well, Mr. Ertl, we have person number 1, who's the owner of the key, person number 2, who does not own the key, but at some point obtains possession of the key. And during the course of obtaining possession of the key, actively bleeds on the key, wipes the bleed off the key. It's not entirely unexpected that you would find the DNA profile of the person who possessed the key and who wiped the blood off the key. That's not an unusual finding, would it not? Well, in that situation, you would have 2 activities promoting finding the second person rather than the first person. If you bleed on the key, you are now supplying a large quantity of your own DNA. And even if the other person's DNA is there, you may mask them because now you have actual bodily fluids rather than stray skin cells. So there's more DNA in blood than I would expect to find from something that had been touched. So you could cover over the other DNA. And if you then wiped it off, now you are physically removing potentially all the DNA that's present, the first person and the second person. And if the second person, not the original owner of the key, had possession of that key for 4 days, one would expect that you are most likely going to find the profile of the person who last possessed the key. Isn't that true? As you explained it, I would expect, yes, to find the second person's. And it would not be unusual at all to find no other DNA profile on that key, would it? No, that would be not unusual. In fact, the likelihood of that occurring is enhanced by the fact that person number 2 actually had possession of the key for, say, 4 days at a minimum. The longer the time, you would expect more contact, more possibility for DNA being deposited. And now let's talk a little bit about this contamination issue. The fact that certain bits of evidence can become contaminated is not all that unusual, is it? The fact that it can happen? Yes. It is not unusual, and it is expected, and we take precautions to prevent that. And, as a matter of fact, contamination can occur, as counsel said, during the collection of the evidence, during the transport of the evidence, and during the analytics of the evidence, as I understood your answer. Is that correct? Yes. All right. Well, it's also possible that contamination of a crime scene could occur before law enforcement even arrives? Correct. And as a matter of fact, in your experience, it's not unusual at all for perpetrators of crimes to take efforts to alter crime scenes, is it? That's quite common to see attempts being made to clean up. All right. And what types of efforts have you seen certain suspects undertake to clean up, as you say, a crime scene? Attorney Buting then says, objection, now we're getting too far afield of this case. Attorney Fallon says, I disagree heartily. Counsel went down this road. We're entitled to respond. The court says, I'll give you a little latitude. And then Attorney Fallon continues, and he tells the witness to continue. I have seen cases where it was a shooting in a carpeted area. We saw some of the blood spatter pattern we talked about previously up on the ceiling and on some of the furniture. And there was absolutely no apparent blood on the carpeting. So we saw a fine, hard to see mist of blood. And you would expect to see then something on the carpeting if someone had been shot there. There was a rug doctor sitting next to it, this area. They had rented the rug doctor and shampooed the carpet. When we ripped up the carpet, a large blood pool on the floor under the carpeting had soaked into the padding. So they had obviously attempted to clean the blood pool from the shooting. And is it possible to clean up blood with certain reagents, such as bleach? Yes, bleach is very effective. We use bleach in the laboratory to clean our work areas. It actually destroys DNA, destroys the blood. It decontaminates it. It's very useful for that. All right. Now, another thing about this contamination issue, just so we're clear, does contamination transform one person's DNA profile into that of another? It cannot change a DNA profile. It can hide a DNA profile, though. So, what you would have then is a mixture. You could have a mixture, or you could fail to see the first person if the second person deposited a much greater quantity of DNA. But it's still interpretable, is it not? Yeah, you would see DNA types and you would be able to interpret them. So I take it it's still possible, then, to have reliable findings, notwithstanding that type of contamination? It's possible. And now, returning again to the question counsel asked about actively bleeding. If a suspect was actively bleeding and entered a vehicle, you would expect to find an impact blood stain, would you not? That would not be uncommon. If they were actively bleeding and blood was dripping from them, then an impact stain would be the blood falling off of the person and gravity pulling it to the floor and hitting. That would be the impact. All right. And what is a contact stain? That's where I'm bleeding, have blood on an item, and the item touches another item. And now I leave some blood on the second item. And you would expect to find that as well. If a person was actively bleeding and had been in a particular vehicle that is now undergoing an examination, if they had touched something with a bloodied up hand or whatever, then you would expect some transfer of blood. Even if it was just a cut on the finger? Sure. Is it possible? Well, before I get there, are you familiar with a phrase called a transfer stain? Well, that's a transfer of blood from one item to another. So, by contact. You are thinking that contact and transfer is one and the same concept? Yes, and I am not a blood spatter pattern expert. I have just I have been to some training. I am able to recognize it when I see it, but I don't interpret it. So I don't know all the specific jargon about swipes and wipes and contacts and transfers, high impact, immediate impact, and low impact cast off. I'm familiar with the terms, but I couldn't necessarily tell you that that's a transfer, not a contact, or a swipe, not a wipe. Well, returning again to our example of the person one and person number two, and person one being the owner of the key and person two being the last one to possess the key. Well, if person number two had been actively bleeding, entered a vehicle holding the ignition key in their right hand, and then attempted to start the vehicle, it would not be unusual at all to find a contact stain near the ignition in that vehicle. Attorney Buting then says, objection to the characterization of not unusual. There's no factual distinction as to how that would occur. The court says, I will sustain the objection based on the form of the question. And Attorney Fallon continues, would you expect to find a contact stain on the ignition? If the person were bleeding with their right hand, a cut on the operating a key with the right hand and trying to start the ignition, I wouldn't think it would be unusual at all to find blood on the key and on the ignition. Now, counsel asked you a series of questions, and I want to talk a little bit more about this blood spatter issue. You can have a crime scene, and let's just take something like a stabbing in which there was blood at the scene. Are you always going to find evidence of a blood spatter stain? No, it would depend on circumstances. What types of circumstances? I can think of a case not too long ago where a woman had been stabbed in her bed, and there was, the blankets and the comforter over her, and was stabbed through that repeatedly. And yet there was no evidence of blood in the room other than bleeding out of her. And the idea was that the knife was going through the bedding and then being pulled out again. It wiped off the blood. It went in, came out, came out clean. And so there was no chance for the blood to fly off the knife and end up on the ceiling or on the floor. So it was a very clean scene. All the blood was contained just to the bedding and to the victim and under the sheets. And if you wanted to further cover up the crime, then you could certainly burn all the bedding, couldn't you? Certainly. So, in effect, then, is it possible to clean up a crime scene? Most certainly. Most crime scenes do get cleaned up and people continue to live in them, the houses or whatever. But it would be, is it possible, based on your training and experience, for instance, to have a pool of blood and, say, on a garage floor, have it cleaned up to such an extent that you would not get a reaction to a phenolphthalein test? Well, knowing what I know, I could probably do it. Bleach would be a good thing. Some sort of peroxide would be a good way to get rid of the red color. The bleach would destroy the blood and the DNA. So it's possible. It's possible. Yes. Attorney Fallon then says, "Your witness." And the court says, "Mr. Buting." And Attorney Buting says, "Sure." And he continues, or he does his recross examination. This other case you mentioned where the gentleman, find it on my notes for a second, please. Yeah, where there was a shooting, a body on the carpet or something, and you were surprised that there was no evidence of blood on the carpet? Correct. But that was explained because the rug doctor was there, right? Right. But there was no blood on the ceiling. Correct. And blood on the wall? Yes. And when you rip up the carpet, there's a pool of blood underneath the carpet, right? That's right. So cleaning a carpet, blood soaks through fabrics pretty well, doesn't it? Yes. So in that instance, whatever the gentleman or defendant did was not good enough. He didn't rip up the carpet and clean the pad underneath it, right? Right. Or this Christine, take the rug doctor, right? Take that in for some processing. I'm sure that probably was done, right? Anyway, let's continue. Now, in this case, are you aware that they ripped all the carpet out and the pad out of Mr. Avery's house? I didn't know that. Okay. So you don't know whether the carpet and the pad and all that was tested for blood in his house or not. I don't know. Okay. Well, we'll get to that later. But in any event, you did not see any blood spatter on his ceiling, right? That's correct. Or on the walls of the bedroom? That's correct. And the walls are paneling, right? I believe so. Are you aware that they ripped the paneling off the walls and took all that out to the crime lab too? No, I wasn't aware of that either. That came later in the case and you weren't involved in that. Is that right? Right. Okay. You also told us a story about the guy who apparently stabbed some woman on the mattress and there was no cast off because he was stabbing her through the bedding, right? Correct. In other words, blankets and comforter on top of the body as it's being stabbed. Correct, right? But, and so in that instance, there wasn't cast off blood that would hit the ceiling or walls or other objects in the room. Is that what you are saying? That's correct. But I assume the person did bleed down into the mattress, right? Yes. And there was a blood-soaked mattress in that case, wasn't there? Yes. And Mr. Fallon asked you if someone would be able to get rid of that evidence, in that instance by burning the bedding, right? That's correct. Any evidence that a mattress was burned in this case? Not that I recall. Did you see any bed springs in the bird pit? No. Or in the burn barrel? No. In fact, when you went to the Avery's bedroom, there was a mattress there, wasn't there? There was. And a box spring? Yes. And there was no blood stain on it, was there? No, there wasn't. Are you familiar with any of these studies of the transfer of trace DNA from one's fingers to objects they pick up? Yes. Are you familiar with Dr. Lee's reports, study? Not in particular. Okay. Trace isn't really your specialty? No. So you are not aware of whether they have done tests that have determined what the likelihood is of the person number one's DNA still being on it when person number two handles it. Is that right? I do know that it varies from person to person how much DNA you deposit on things. Okay. But in fact, when using the hypothetical Mr. Fallon had, person number two is handling the key after person number one. The more common finding would be two people's DNA, wouldn't it? If they were each just handling. Okay. Any evidence of blood on the key in this case that you are aware of? I know nothing of the key. I didn't ever see the key. Okay. And you said you were looking for blood, but you knew this was by then, by the time you went into the house, you knew that there was a Toyota RAV4 that had been seized and taken to the crime lab, right? Yes. So if you had walked in that bedroom and seen, right in plain view, a car key that looked like a Toyota car key, you would have made note of that, wouldn't you? Attorney Fallon says objection beyond the scope of redirect. Attorney Buting says you talked about the key. Attorney Fallon says not in that context. And the court says, I'm going to sustain the objection. Attorney Buting says, all right. And the court says, I think that question has already been asked and answered as well. Attorney Buting says, okay, that's all I have. Thank you, sir. The court says, all right, the witness is excused. Mr. Fallon, you can call the next witness. Attorney Fallon then says, we will move Exhibit 156 into evidence, please. The court says, any objection? Attorney Buting says, I'm sorry, which one is that? I have no objection to that. And I would move Exhibit 159, 160 in as well. Attorney Fallon says 159 is the statement of qualifications. Attorney Buting says correct. Attorney Fallon says, and 160 was the emails. I don't have any objection. The court says, all right, those exhibits are all admitted. And then says, jurors, if you want to stand up and stretch a minute before we hear our next witness, you may. And those of you in the audience, if you wish, you may. So that's where we'll leave things for right now. And we heard a lot, right, about faint luminol reactions in the garage that turned out not to be blood, about bones being sifted from a burn pit without proper archaeological methods. There was no mapping, no documenting of the exact locations, just everything shoveled into one box. And remember, this is the state's own field response person saying this, explaining that he wasn't allowed to process the scene the way his training taught him to. And that's important because if blood or bones are found, but no one can say precisely where they came from, how reliable is that evidence really? Now, let's hear what Kathleen Zellner, Stephen's post-conviction attorney, had to say about John Ertl and his team, along with their collection methods. Before we get into that, though, did you know that in the past month, over 2,200 people have watched these episodes? And that's just on YouTube. That doesn't even include everybody in the podcast world. But here's the thing. Almost 1,700 of you are not subscribed yet. If you're one of them, hit that subscribe button so you don't miss the next episode. So let's talk about what Kathleen Zellner later found, because it really changes how you hear his testimony. Ertl wasn't just some guy taking pictures. Well, he had a guy to do the picture taking and bagging samples. He was the one who actually started pulling bones out of Stephen Avery's burn pit on November 8th. And how did he do this? He did this with a shovel, not with a forensic anthropologist, carefully marking, where each fragment was found, not with grids or strings or maps or anything like you'd expect in a murder case. Just scooping literally. And that's huge because once you start shoveling bones and ashes together, you lose all context. You can't say exactly where they came from, or even if they all came from that same pit. Remember, bones were also found in burn barrels and in the Redant quarry. And we haven't gotten to quite all of this yet, but this is coming up. By mixing all of this together, The lab basically erased the ability to prove the state's story that this burn pit outside of Stephen's home was actually the crime scene. Zellner then later argued that this wasn't just sloppy, it was devastating to the actual truth. The state leaned really hard on this pit being the place where Teresa was eventually destroyed, for lack of a better term. But because of the way that the field team handled things, there's no real scientific way to back that up. And then don't forget, he was also one of the people who physically took custody of Teresa's RAV4 and then transported it to the crime lab. And that puts him right in the middle of one of the biggest questions in this case. How secure was that vehicle? Who really had access to it before it was even processed for evidence? So even though Ertl, he doesn't come across, as the most dramatic witness in the courtroom, we've got some coming up that are, his behind the scenes work shaped this case in a big way. And Zellner makes it really clear. The way that he handled the evidence left cracks in the state's story that they're trying to develop out of this. Next time, we're moving away from Ertl and we're moving into testimony from two very different law enforcement officers. The first one up is Deputy David Siders of the Manitowoc County Sheriff's Department, who says that he discovered a burn barrel containing Teresa Halbach's mobile phone and camera on November 7th. We'll then hear from Sergeant William Tyson of the Calumet County Sheriff's Department, who was tasked with securing the RAV4 on November 6th. So both of those will be in the next episode. It's not going to be a very long episode. There's not very many pages that they cover, but they will be up next for sure in the next episode. Until then, thank you all for listening. I appreciate each and every one of you. If you haven't subscribed yet, please do so. I appreciate it so much. It really helps this channel, helps keep me going, that's for sure. And we'll talk really soon. Bye for now.